My name is Ricardo Riesco. I'm the head of the Fiscalía Nacional Económica, which is a Chilean antitrust competition prosecuting agency. Today in the panel, I'm going to talk how Chilean laws date back to 1959, so they are pretty old for international standards. They have undergone different amendments throughout time, and the last amendment to Chilean competition laws was in 2016, in August 2016. This was a major amendment to our laws, and it has substantially changed the landscape of antitrust in Chile. On the one hand, relating to cartel prosecution. First, agreements between competitors involving price fixing, market or client allocation, and bid rigging are now hardcore cartels and subject to a per se rule. Also, hardcore cartels in Chile are now a criminal offense, punishable with up to 10 years in prison, with having at least 1 year of effective prison, even if you have no prior criminal record. The first leniency applicant is immune from antitrust and criminal liability. The second leniency applicant has a reduction in the fine applicable to him, and also a reduction of the criminal sentence. Also, fines for antitrust violation have substantially increased. They may be up to 30% of the turnover of the product or service involved in the violation, or alternatively, twice the economic benefit obtained by the violation. If none of these parameters can be determined, the fines are capped at $55 million. The leniency program was adopted in Chile in 2009. So this year we are celebrating the 10-year anniversary since the implementation in Chile of our leniency program. It has been very successful. So far we have had 6 cases involving leniency applicants, which have resulted in fines for a total amount of $70 million so far. For the Chilean competition system, our leniency program is a vital tool to deter, detect, and investigate cartels. On the other side, side of the reform in 2016 affected the merger control system applicable in Chile. Now we have a mandatory pre-merger control system which is entrusted in the Fiscalía Nacional Económica. Before that, the Fiscalía Nacional Económica was just a prosecuting agency. Now we have these adjudicative powers relating mergers. We have a 2-phase analysis with very strict timelines provided for in the law. First of all, 10 working days to determine whether the filing is complete or not. Once the filing is complete, we have 30 working days to determine what to do with the merger. We can approve it unconditionally, we can approve it with remedies, or we can send it to phase 2. In phase 2, which is a 90-day working day proceeding, we can once again approve the merger unconditionally, approve it with remedies, or prohibit the merger. Only in cases where we prohibit the merger, this decision by the Fiscalía may be reviewed by the Chilean Competition Tribunal. It has happened twice that the Fiscalía has blocked a merger, and in one case it was challenged before the Chilean Competition Tribunal, and said decision was overturned by the tribunal. So far, our merger control system has worked very fine, and we encourage, in case of international mergers, the parties to notify in Chile alongside with other main jurisdictions like the US or Europe, in order to enhance agency collaboration and to obtain an approval, whatever the remedy or not, as soon as possible. We are working as hard as possible to make the process as efficient and to comply also with the legal standard applicable by the law in Chile, which is whether the merger produces or a substantial reduction of competition. Thank you very much.